back, future CPAs and attorneys. For this video, we will be tackling about some articles in the limited partnership and sections from the Revised Corporation Code of the Philippines. So ready your pens, your notebooks, and your books, and let's get started.
Article 1843. This article defines a limited partnership, which is one formed by two or more persons under the provisions of the following article, having as members one or more general partners and one or more limited partners. This article has also given the characteristics of a limited partnership, which are the following. It is formed by compliance with statutory requirements. One or more general partners control the business and are personally liable to creditors. One or more limited partners contribute to the capital and share in the profits but do not participate in the management of the business. The limited partners may ask for return of their capital contributions under the conditions prescribed by law, and the partnership debts are paid out of the common fund and the individual properties.
The limited partnership is thus composed of two kinds of partners, the limited partner and the general partner. The key characteristic between these two partners is their extent of liability. The limited partners have liability that is only limited to their interest in the firm or their contribution in the business, while the general partners are liable up to the extent of their personal property.
Article 1845. This article talks about the contributions of a limited partner and that it should only be cash or other property, but not services.
In the past article, we have mentioned the term limited partner, and that is the kind of partner whose liability is only up to the extent of his personal contribution in the firm. This means that the limited partner can only contribute money or property and not services, because a person who contributes services is an industrialist partner or a general partner. And remember that a general partner is a partner whose liability extends to his personal properties. It shall also be noted that the law is not satisfied by the limited partner's contribution in promissory notes, checks, or bonds. But if the limited partner has actual money in the bank, then the check may be treated as an actual payment or contribution.
For example, there are three partners, namely Maria, Cole, and Jem. Maria contributes cash and is a limited partner. Cole contributes cash and is a general partner, while Jem contributes services and is also a general partner. Take note that a general partner is one whose liability to third person extends to his separate property. So if Maria, in addition to the cash that she contributed, will also contribute services, she shall become a general partner. Article 1846. This article talks about the surname appearing on a partnership name. A limited partner's surname shall not appear in the partnership name unless, first, that surname is common with another general partner, meaning another partner who is a general partner has the same surname, or, second, before the limited partner became a part of the partnership, his surname is already carried under the name of the partnership.
As a general rule, the limited partner who violates this law or rule shall be liable to the partnership creditors.
Article 1847. Under this article, we talk about certificate that contains false statement and how a certain partner becomes liable in connection to such certificate.
Under this article, a partner to the certificate containing false statement is liable if, number 1, he knew about the false statement at the time he signed the certificate, which means he has knowledge of such act. Number 2, he failed to amend or file a petition for the cancellation of the said contract. In this case, the person or the partner doesn't have any prior knowledge of the existence of such contract. However, he did acquire subsequently the knowledge about such contract, about the existence of a contract with a false statement, but he failed to cancel or file a petition to cancel of the said contract. Third, the person relied on the false statement in transacting the business. And fourth, due to its reliance, the person suffered a loss.
For example, the contribution of Edita, a limited partner, is erroneously stated in the certificate as 6,000 pesos instead of 3,000. In this case, the partner is liable to innocent third persons for the difference of 3,000. Article 1848. A limited partner shall not become liable as a general partner unless, in addition to the exercise of his rights and powers as a limited partner, he takes part in the control of the business.
Remember that a limited partner is a partner whose liability to third persons is limited to his capital contribution. The key characteristic in here for the limited partner is his abstinence from the participation of any transaction of the business firm, which is essential in exempting him from the liabilities of the firm. If he becomes involved in the management of the firm's business, he becomes a general partner and he becomes liable the same way as a general partner. So even if he was given a bare grant of apparent control to the partnership, he is not liable as long as he has not actually participated in the control of the business. But we should also take note that being interested in the success of the partnership does not forfeit the right of a limited partner to make suggestions or express opinions as to the advisability of certain transactions.
Article 1849. After the formation of a limited partnership, additional limited partners may be admitted upon filing an amendment to the original certificate in accordance with the requirements of Article 1865.
Under this article, the law requires that there is proper amendment to the certificate, which must be signed and sworn by all the partners when additional limited partners are admitted after a limited partnership has been formed.
Article 1851. Under this article, we talk about the rights of a limited partner when it comes to protecting his interest in the firm. So the general partner and limited partner is different in some aspects, and the power of the limited partner is much more limited than those of a general partner. However, the limited partner shall have the same right as the general partner to: first, have the partnership books kept at the principal place of business of partnership, and inspect and copy any of them at a reasonable hour. Second, have on demand true and full information of all things affecting the partnership, and a formal account of partnership affairs whenever circumstances render it just and reasonable. Third, have dissolution and winding up by decree of court.
Take note that the rights of a limited partner is necessarily lesser than the general partner since they cannot take part in the control of the business.
Article 1853. This article talks about a person who is a general partner and also a limited partner at the same time at the same partnership. So a partner may be a limited and a general partner at the same time, provided that this is stated in the certificate signed, sworn to, and recorded in the Office of Securities Exchange and Commission.
If this is the case, his powers and rights would be of a general partner, which means he would be liable up to the extent of his separate property. However, with respect to his contributions, his rights would be of a limited partner.
Article 1855. This article talks about a situation or a case where there are several limited partners. So as long as it is agreed by all the members, there could be a preference given to some limited partners over other limited partners in regards with the return of their contributions, their compensation by way of income, or any other matter. If there is no agreement, these limited partners will have equal rights and no preference shall prevail over the others. Article 1856. A limited partner may receive from the partnership the share of the profits or the compensation by way of income stipulated for in the certificate, provided that after such payment is made, whether from the property of the partnership or that of a general partner, the partnership assets are in excess of all liabilities of the partnership, except liabilities to limited partners on account of their contributions and to general partners. Under this article, it is stated that there is a condition when a limited partner receives his share of profits or compensation by way of income, and that is, it should be in excess of partnership liabilities. This means third-party creditors have priority over limited partners' debts.
Also, take note that the liabilities of a limited partner and a general partner are not included when determining the liabilities of a partnership.
Article 1860. Under this article, we talk about the effects of retirement, death, insolvency, insanity, or civil interdiction of a general partner and a limited partner.
The effect of retirement, death, insolvency, insanity, or civil interdiction of a general partner and a limited partner is not the same. If it is a general partner, it dissolves the partnership. However, if it is a limited partner, it does not result to dissolution unless there is only one general partner. If the business is continued by the remaining partners under the given right in the certificate or with the consent of all members, the certificate must be amended.
Article 1861. Under this article, we talk about the executor or administrator of a deceased limited partner. So the administrator shall acquire the rights of a deceased limited partner for the purposes of settling the affairs of the said partner. Take note that the administrator may only constitute the assignee as a substitute limited partner if the deceased partner was empowered to do so in the certificate. Also, the estate of a deceased limited partner shall be liable for all his liabilities as a limited partner. Article 1866. Under this article, we talk about why a certain partner is not a proper party to proceedings by or against a partnership. So remember that a limited partner's liability is only to the extent of his interest in the firm. Since limited partners are not principals in the partnership, they have no right of action against third persons whom the partnership has any enforceable claim. With this, limited partners are not a proper party to proceedings by or against a partnership unless that limited partner is also a general partner.
We are done with our first topic for this video, which is the limited partnership. Now let us move on and discuss some sections from the Revised Corporation Code of the Philippines.
Section 1. Title of the Code. This code shall be known as the Revised Corporation Code of the Philippines. Republic Act 11232, or the Act providing for the Revised Corporation Code of the Philippines, was signed into law by President Rodrigo R. Duterte last February 21, 2019. It amends a 38-year-old corporation code in an effort to improve the ease of doing business in the Philippines. Section 2. Corporation defined. Under this section, we defined corporation as an artificial being created by operation of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or incidental to its existence.
As an artificial being, a corporation has a personality separate and distinct from its stockholders. With this thought, we have come up with a general rule, and that is a corporation may not be made to answer for acts or liabilities of its stockholders and vice versa. In simple terms, a corporation is not liable for any personal transactions or liabilities made by its stockholders and vice versa.
To illustrate, the corporation and not its stockholders is personally liable for its corporate debts and liabilities. The stockholders are liable only to the extent of their subscribed capital. This means that if a creditor sues a corporation and the debt is much more than the subscribed capital of the stockholders, then the stockholders will not be held liable for the deficit. Its liability for debt will be limited only to the extent of the stockholders' subscribed capital. Section 3. Classes of Corporation. Section 3 of the Revised Corporation Code of the Philippines gave the definition of stock and non-stock corporation. Stock corporations are those which have capital stock divided into shares and are authorized to distribute to the holders of such shares dividends or allotments of the surplus profits on the basis of the shares held. While non-stock corporation is a residual definition, which means all other corporations that doesn't belong to stock corporations are non-stock corporations. Section 4. Corporations created by special laws or charters. Under this section, we talk about special laws, which is a law that applies to a particular place or specially to a particular member or members of a class of persons or things in the same situation, but not to the entire class, and that is unconstitutional if the classification made is arbitrary or without a reasonable or legitimate justification or basis.
So in simple terms, this article is telling us that if a corporation is created under a special law or charter, then that corporation shall be governed by such special law or charter.
Section 5. Corporators and incorporators, stockholders and members. Section 5 gives us the definition of corporators and incorporators. Corporators are stockholders or shareholders in a stock corporation, or they could also be members in a non-stock corporation. They are those who compose a corporation. While incorporator are stockholders or members mentioned in the Articles of Incorporation as originally forming and composing the corporation and who are signatories thereof. Section 7. Founders' shares. Founders' shares are issued to the originators of a company. Often, the stock does not receive any returns up to the point that a dividend is payable to the common stockholders.
According to the law, a founder's share may be given certain rights and privileges that are not enjoyed by other owners of the stocks. It was also mentioned that when one is granted the right to vote or to be voted for in the election of the directors, it should not exceed the limited period of 5 years from the date of incorporation. It should also be noted that such right should not violate any dummy law, Foreign Investments Act of 1991, and other pertinent laws.
Section 8. Redeemable shares. Under this section, we tackle about redeemable shares and its definition, which is defined as shares which may be purchased by the corporation holders of such shares upon the expiration of a fixed period and upon such other terms and conditions stated in the Articles of Incorporation and their certificate of stock representing the shares, subject to rules and regulations issued by the Commission. These are also shares that a company has agreed that it will or may redeem at some future date. The shareholder will still have the right to sell or transfer the shares subject to the Articles of Association or any shareholders' agreement. Section 9. Treasury shares. Treasury shares are shares of stocks which have been issued and fully paid for, but subsequently reacquired by the issuing corporation through purchase, redemption, donation, or some other lawful means.
Please take note the difference between the redeemable shares and the treasury shares. So redeemable shares are redeemed while treasury shares are often repurchased.
Section 10. Number and qualifications of incorporators.
Section 10 tackles about the numbers and qualifications of incorporators. The term incorporator have already been discussed in our past section, but for the purpose of refreshing memory, an incorporator is a stockholder or a member mentioned in the Articles of Incorporation as originally forming and composing the corporation.
These certain incorporators have qualifications to meet. First, it could be a partnership, association, or corporation, singly or jointly with others, but no more than 15 in number. Second, the purpose of organizing such corporation is lawful. Third, natural persons who are licensed to practice a profession and partnerships or associations organized for the purpose of practicing a profession shall not be allowed to organize as a corporation unless otherwise provided under special laws. Fourth, incorporators who are natural persons must be of legal age. And fifth, each incorporator of a stock corporation must own or be a subscriber to at least one share of the capital stock. Section 12. Minimum capital stock not required of stock corporation. Minimum capital stock is the total amount of money received from investors or shareholders in exchange for shares of stock. This form of capital can be paid through actual cash or tangible or intangible property. However, in this section, it was stated that stock corporations shall not be required to have a minimum capital stock except as otherwise specifically provided by special law. Section 13. Contents of the Articles of Incorporation. All corporations shall file with the Commission Articles of Incorporations, which will contain the following: the name of the corporation, the specific purpose, the place of the principal office, the term or how long the corporation shall exist, the names, nationalities, and residence addresses of the incorporators, the number of directors and the number of trustees, the name, nationalities, and residence addresses of persons that shall act as directors. If it is a stock corporation, the amount of its authorized capital stock, number of shares, the par value of each, names, nationalities, and residence addresses of the original subscribers must be disclosed. And if it is a non-stock corporation, what should be disclosed is the amount of its capital, the names, nationalities, and residence addresses of the contributors. And lastly, such other matters that is consistent with law. Section 23. Election of directors or trustees. Except when the exclusive right is reserved for holders of founders' shares under Section 7 of this code, each stockholder or member shall have the right to nominate any director or trustee who possesses all of the qualifications and none of the disqualifications set forth in this code. At all elections of directors or trustee, there must be present, either in person or through a representative authorized to act by written proxy, the owners of majority of the outstanding capital stock, or if there be no capital stock, a majority of the members entitled to vote. The election must be by ballot if requested by any voting stockholder or member. In stock corporations, stockholders entitled to vote shall have the right to vote the number of shares of stock standing in their own names. So the said stockholder may vote such number of shares for as many persons as there are directors to be elected, cumulate said shares and give one candidate as many votes as the number of directors to be elected, multiplied by the number of the shares owned, distribute them on the same principle among as many candidates as may seem fit.
It shall be noted that the total number of votes shall not exceed the number of shares owned by the stockholders as shown in the books of the corporation multiplied by the whole number of directors to be elected. Now the nominees for directors or trustees receiving the highest number shall be the one elected. So that is the end of our video. I hope you learned something about the limited partnership and the corporation code of the Philippines. So remember what we discussed in this video, and I'll see you soon, my future CPAs and attorneys.